Generally, principals are bound by contracts their agents enter on their behalf. But what if a former agent goes rogue and enters a contract on behalf of the principal after the agency relationship ends? The Arizona Court of Appeals considered the limits of when a principal is bound by the unauthorized acts of a former agent in Arizona Land Advisors LLC versus Studio City Lofts LLC. On July 17, 2012, John Lupypciw was removed from his position as the manager of Studio City Lofts LLC. However, several months later, Lupypciw purported to sign a listing agreement with Arizona Land Advisors on Studio City Lofts' behalf. Under the agreement, Land Advisors had the exclusive right to sell a parcel of property owned by Studio City for 1 year. The agreement entitled Land Advisors to a 6% commission if the property sold during that year, regardless of whether Land Advisors found the buyer. Studio City, which had no knowledge of the listing agreement, entered involuntary bankruptcy 2 days later. The bankruptcy was resolved through a settlement agreement that didn't include Land Advisors. However, acknowledging that Lupypciw had been attempting to sell Studio City's property, the agreement gave him the authority to sell it for 60 days, subject to the bankruptcy court's approval. 3 months later, Studio City sold the property to a third party without any involvement from Land Advisors. Land Advisors filed a breach of contract claim, arguing that it was entitled to its 6% commission under the listing agreement's terms. The trial court granted Studio City's motion for summary judgment and awarded Studio City a portion of its requested attorney's fees. Land Advisors appealed to the Arizona Court of Appeals.